Alright guys, so as most of you know at this point, Judge Keith Carsten denied Stephan motions to suppress evidence found on his phone as well as on his Google account. I'm going to actually read why Judge Keith Carsten ultimately denied the defense's request for this suppression of evidence right now. So if you're interested in hearing that, take a listen. Alright, so up first, the order denying the defendant's motion to suppress evidence obtained from the unlawful search of the cell phone and unlawful seizure of the cell phone. The defendant argues that the initial search of the defendant's phone exceeded the scope of his limited consent. Specifically, the defendant contends that while the defendant consented to certain searches of his phone, the detectives exceeded the narrow scope of these searches. Warrantless searches are per se unreasonable, subject only to a few specifically established exceptions. While consent is one exception to the warrant requirement, the state has the burden of proving that consent was freely and voluntarily given. Under Florida law, the state must show by clear and convincing evidence that the defendant freely and voluntarily consented to the search. When consent is obtained after illegal police activity such as an unauthorized search or arrest, the unlawful police action presumptively taints and renders involuntary any consent to search. There is no bright line test for determining the scope of consent to a warrantless search. Such a determination is made on a case-by-case basis. The scope of the search is generally limited to what a reasonable person would have understood to be the object of the search during the exchange between the person and the police. The state avers that the defendant's argument depends on his misleading and incomplete recitation of the limited consent he gave to Detective Tagler. The court agrees. On February 27, 2024, Detective Tagler and Detective Acosta interviewed defendant at his residence. The detectives were in plain clothes, the defendant was not in handcuffs, and the defendant was free to leave. At 7:37 p.m., Detective Tagler asked permission to look at his Maps app on his phone. The defendant answered, "Yeah, that's fine." The defendant willfully and voluntarily unlocked his cell phone and handed it to Detective Tagler. Detective Tagler soon thereafter asked permission to take a picture of his history. The defendant again consented. At 7:57 p.m., Detective Tagler asked again if the defendant could unlock his phone so they could view its contents. The defendant willfully and voluntarily unlocked the phone. The detectives interviewed the defendant a second time the following day. During the interview, Detective Tagler asked permission specifically to download his phone and asked the defendant if he needed a warrant for his phone. The defendant again consented and provided the detectives his PIN number for his phone. No evidence suggests at this point that the detectives exceeded the scope of the search in any unreasonable manner. The evidence makes clear that the defendant unlocked his cell phone and gave it to Detective Tagler on multiple occasions and unequivocally consented to them viewing map data and documenting his search history. Even after Detective Tagler asked if a warrant is needed, the defendant nevertheless consented. Most importantly, the defendant gave consent to law enforcement to download the cell phone and go through the phone. A reasonable person under the circumstances would understand the scope of the consent to include access to all contents that were searched in this case, including call history. Furthermore, the evidence is clear that the defendant was free to leave and that the detectives interacted with him without coercive tactics. Consequently, the state has established by clear and convincing evidence that the defendant freely and voluntarily consented to the searches and that law enforcement did not exceed the scope of the defendant's consent. Now, regarding the motion to suppress evidence obtained from the unlawful seizure of Stephan's cell phone, the defendant contends that his cell phone was unlawfully seized by Detective Tagler for over 9.5 hours without consent or probable cause. To support his claim, defendant asserts that Detective Tagler made no attempt to obtain a warrant despite the availability to do so. The evidence demonstrates that Detective Tagler had probable cause to believe there was evidence of a crime contained in the defendant's cell phone at the time of the seizure. Probable cause requires a practical, non-technical probability that incriminating evidence is involved. Probable cause only requires that the facts available to an officer would warrant a person of reasonable caution in the belief that certain items may be useful as evidence of a crime. As the state correctly points out in its response, at the time of the seizure, Detective Tagler knew that Madeline Soto had been missing for over 24 hours and the defendant was consistently identified as the last person to have seen her prior to her disappearance. Additionally, law enforcement had tag reader evidence that the defendant was not being truthful with regard to his movements on February 26, 2024. The defendant also regularly used his cell phone to speak with Madeline Soto. Consequently, the court finds that the facts available to Detective Tagler after consensually searching the defendant's phone is evidence that would warrant a person of reasonable caution in the belief that the phone may be useful as evidence of a crime. Furthermore, Detective Tagler had exigent circumstances to seize the phone. The fear of imminent destruction of evidence must be objectively reasonable. Specifically, in determining whether state agents reasonably feared imminent destruction of the evidence, the inquiry is whether the facts as they appeared at the moment of entry would lead a reasonable, experienced agent to believe that evidence might be destroyed before a warrant could be secured. Here, evidence shows that Detective Tagler had an objectively reasonable fear that the cell phone would have been later destroyed prior to securing a warrant. Detective Tagler, based on the answers of the defendant, has reasonable belief that he had attempted to destroy cell phone evidence by factory resetting it at some point during the same day. The destruction of the cell phone was also likely more imminent after meeting with Detective Tagler and Acosta, given that he knew he was under suspicion and they showed interest in his phone. Because law enforcement was under the reasonable belief that destruction of the cell phone was imminent and they had probable cause to believe there was evidence of a crime contained on the cell phone, Detective Tagler's seizure of the defendant's cell phone was lawful. On to the next document, the order denying the defendant's motion to suppress evidence obtained from Google search warrant. The defendant contends that all evidence obtained through the Google warrant must be suppressed. To support his claim, the defendant makes three main arguments. The first one being the Google warrant relied entirely on illegally obtained evidence. The defendant first asserts that law enforcement exceeded the scope of Mr. Stern's initial consent, retained his phone without proper authorization, and conducted a coerced midnight download. Because law enforcement used the information extracted from the searches to support the application for the Google warrant, the defendant alleges that the state cannot justify the warrant under any attenuation or independent source doctrine because the warrant was built entirely on tainted evidence and intentional misconduct. The defendant concludes that the evidence must therefore be suppressed as fruit of the poisonous tree. The defendant fails to establish that his searches were coerced or otherwise improper. The evidence makes clear that the defendant willfully and voluntarily unlocked his cell phone and gave it to Detective Tagler on multiple occasions and unequivocally consented to them viewing map data and documenting his search history. Even after Detective Tagler asked if a warrant is needed, the defendant nevertheless consented during interviews. Most importantly, the defendant gave consent to law enforcement to download the cell phone and to go through the phone. A reasonable person under the circumstances would understand the scope of the consent to include access to all contents that were searched in this case, including call history and GPS data. During interviews with law enforcement, the defendant was free to leave. Consequently, the defendant freely and voluntarily consented to the searches, and that law enforcement did not exceed the scope of the defendant's consent. The state is therefore correct in its response that law enforcement relied on information properly obtained during consensual searches of the defendant's cell phone to support the affidavit for search warrant. Consequently, the warrant at issue was not tainted and was not constitutionally invalid as the fruit of illegal searches. Next, the defendant asserts that the warrant application fails to establish probable cause. To establish probable cause, a supporting affidavit for issuance of a search warrant must satisfy two elements. First, that a particular person has committed a crime, the commission element, and second, that the evidence relevant to the probable criminality is likely located at the place to be searched, the nexus element. A magistrate is not required to leave common sense at the courthouse door when evaluating whether a supporting affidavit satisfies the nexus element and supports a finding of probable cause. Here, the affidavit for search warrant for defendant's Google account provided a sufficient basis for the court to determine that evidence related to child would likely be found on the defendant's Google account. Specifically, the affidavit points to the fact that the defendant factory reset his cell phone the same day that Madeline Soto was last seen. Detective Heller also indicated that interviews of the defendant were conducted and that the defendant consented to a search of his phone. During the search, several files were located. Further, the affidavit stated that the defendant's images were stored and backed up on his Google account. Additionally, the affidavit further describes that evidence related to interference of child custody was contained within the defendant's Google account. Detective Heller detailed that Madeline was reported missing by her mother on February 26, 2024. The defendant had stated that he dropped Madeline off at Peace United Methodist at 8:40 a.m., although classes did not start until nearly an hour later. However, a license plate reader captured the defendant's vehicle tag traveling away from Hunters Creek Middle School at 8:10. Madeline Soto never showed up to school. The state is correct that at the time the warrant application was filed, it was probable that other information on the defendant's cell phone prior to the factory reset was backed up to his Google account, such as GPS data, which was described in the affidavit for the search warrant. Consequently, the warrant application was backed by substantial evidence satisfying both prongs of Sanchez. Defendants claim that the warrant failed to establish probable cause is therefore without merit. The defendant further argues that the warrant was overbroad in its time frame for searches. The warrant permitted the search of data from January 1st, 2020 to present, yet according to the defendant, provided no factual basis for the expansive 4-year period. However, courts often note that child collectors maintain their materials for significant periods of time. Here, there is evidence to support the defendant was an individual that fell into this category, given that the material was his stepdaughter and that it was located on his phone and backed up onto his Google account. Accordingly, the warrant is not tainted for having an overbroad temporal scope. And then 3, in his final argument, the defendant contends that the warrant lacks required particularity for digital searches. The defendant avers that the warrant's authorization to search any and all stored electronic communication or files associated with the Google account is impermissibly broad in violation of the Fourth Amendment. The court agrees with the state that even if the warrant was impermissible as overbroad, the good faith exception nevertheless applies. The good faith exception applies when a law enforcement officer acting with an objective good faith obtains a search warrant and acts in accordance with the warrant and scope. Suppression of the evidence obtained is not appropriate even if the court later determines that there was no probable cause. Exclusion of the evidence is appropriate in cases which the affidavit is so lacking in probable cause that reliance on it would be unreasonable. Here, law enforcement did not provide any false or misleading information in the affidavit for search warrant. As stated through this order, the affidavit was not lacking in reliance, so law enforcement relying on the warrant was not unreasonable. Additionally, the court finds that the good faith exception applies and suppression of the evidence is inappropriate. So just like the other 2 motions to suppress, the motion to suppress evidence obtained from the Google search warrant is also denied.